Hey, welcome back, everyone. This is Essen Raza from Century 21 Innovative Realty, back with you for episode number 17. And this one I had marked on my calendar for quite some time, and I reached out to Dan Schofield from SFG Paralegal Services, who's going to enlighten us about landlord, tenant tips, and a whole bunch of things. So thanks for coming on the show, man. I really appreciate it.
Hey, it was an absolute pleasure coming in to see you. Thank you very much.
So you and I think we may or may not have met, but this was like a while ago at C21.
Yep.
You came to do a presentation. I think I was there. That's how I remember your name. And I've put your name down since then. But I've seen your stuff. I've heard about you. You do a lot of great stuff. But what's keeping you busy these days?
Obviously, the big one for us, especially as a paralegal firm, is landlord and tenant board work.
Right.
It's a never-ending stream of clients coming in, both landlord, few tenants.
Yeah.
Most of our work is landlord work. A lot of realtors calling us in a panic, seeing what they can do to advise their clients. So
I've called you a couple of times too, I think.
Yeah, exactly. So that's pretty much where we're at right now.
Nice. And your firm, how do you guys help landlords specifically in terms of anything from what they're going through, non-payments of rent? Is that something that you guys help facilitate, or?
Yeah, so we do everything from non-payment of rent, damage to the rental unit, owner own use applications, purchaser own use applications. Those two are big ones that we do a lot of. A lot of landlords kind of keep us on retainer, and they just kind of call us whenever they have a problem. So
Gotcha.
In a lot of situations, they avoid a long, protracted process with issues because they've called us in advance and said, hey, this is what I'm thinking of doing. What's the best way for me to do this?
Right. So like my example, I've got a lot of clients who have issues with their own tenants. But sometimes what I find is that they try to fix it on their own. So their own paperwork, their own filing. And what ends up happening is that they'll put the wrong name down or the wrong address, and then they got to start the process over again. So I think going with a professional or a paralegal like yourself, I would say probably saves a lot of that hassle, because now we know we're doing it through the right channels, right?
Well, I think the important thing to understand is a judge or an adjudicator can only be as forgiving as the legislation governing what they're doing.
Right.
So in the Residential Tenancies Act, it specifically says that a name must be correct. It specifically says that an address must be correct. It specifically says that if it's a non-payment of rent application, that amount must be correct.
Yeah.
It specifically says that if you give a termination notice, it must be correct. The date that you put must be correct.
Right.
There's no discretion to change it.
Yeah.
So we had a client come to us, and, you know, one of the things he did, because he hand served the notice to the tenant, he didn't put the city or the postal code on it.
Okay.
And he argued, well, I don't have to put the city or the postal code because I delivered it to the tenant by hand. But the legislation doesn't say if you deliver it by hand, you can omit half the address.
Right.
Or, you know, another good one that I have, I tell this story all the time. If you did one of my presentations, I'm sure you heard it. When a client comes to us and asks us to do work for them, we have intake forms and various things that we get them to fill out to make sure the information we have is accurate.
Right.
And I had one guy call me up, look, my tenant hasn't paid rent in 2 months. The rent's $1,700 a month. Great. Send them the intake form, get it in, you know, get them into the process. They put $1,700 on the intake form. Yeah. So I go, perfect, no problem. I move forward. I complete the notice. I send it to them for approval. The approval is $1,700 a month for rent. Absolutely. Everything's fine. We get to a hearing, and the tenant's legal representative stands up and goes, Madam Chair, this application is defective and it needs to be dismissed. Oh, wow. And I looked at my client. I'm like, defective? How is it defective? And the adjudicator says to the rep, well, how is it defective? He goes, well, rent is actually $1,699.47 a month. Really? And they have $1,700 a month for rent. I just looked at my client. Yeah. He looked at me, and I went, well, this is what happens when you give me the wrong information. And we had to start all over again. Yeah. My client's saving grace is this was a pre-COVID world where hearings for non-payment of rent took place in 45, 60 days. Yeah. So he really wasn't out that much money at the end of it. But now in a COVID world, that's disastrous. You've waited 12 to 18 months to get to a hearing, you know, because it was filed back in 2020 or 2021 when the backlog was really bad. And you get to hearing, and all of a sudden it's dismissed over 40 cents, 50 cents. I mean, it's disastrous. Yeah. And then they start all over again. And we're going to get back there in 6 months. So it's not going to be as long of a wait, but by 6 months, you're already at $30,000, $35,000 a month in rent. Sometimes over if you live in Toronto. I have a client who has $6,000 a month rental properties. He goes without rent for 6 months. He's already above the $35,000, which is the maximum amount that the board can give back to you. And now he has a choice. Do I stay with a paralegal at the Landlord and Tenant Board, or do I hire a lawyer and go to Superior Court? So you're looking at a paralegal who's, let's say, $1,500 versus a lawyer that's $10. It's a tough gig.
So accuracy is obviously really, really important.
Huge.
Yeah, that's a big deal. So, I mean, one of the main, I guess, issues that a lot of people are going through right now is obviously non-payment of rent from their tenants. So if you can kind of give our audience a walkthrough as to what that process would look like if a client came to you and said that I want to evict my tenant because of non-payment. How does that work exactly?
Well, there's certainly non-payment of rent notices that somebody would use. And on the surface, they look very easy. And if you print out the instructions and you fill them out, you may not even need somebody like me. It really depends on you. You have to know. But here's the situation. The biggest mistake people make with non-payment of rent is not the notice. It's not the application. It's not going to a hearing. It's that they accept excuses.
Okay.
Rent is $2,000 a month. It's due on the 1st. Tenant says, "Oh, here's $1,000. My, spouse lost their job, or I had a problem with my pay." Or the big one that we'll hear is, "My bank account was compromised due to fraud." Right. So I can't pay the full amount right now. Give me a week. Give me 2 weeks. So they give them 2 weeks, and then there's another excuse, and then all of a sudden, instead of paying $1,000, $1,500 in chunks, they stop paying altogether. Oh, give me I swear, just give me another month and a half, and I'll get this taken care of. And a lot of landlords, especially non-corporate landlords who don't do this for a living, some of them, they feel bad about it, so they ultimately give it to them. So now the problem is like I said, there's a lot of delays at the Landlord and Tenant Board. So let's walk this through the process if you retain me right away versus 3-4 months down the road. So our advice to all of our clients, corporate, not corporate, doesn't matter whether you have one house or 5,000 rental properties. If rent is due on the 1st and it's not paid by 11:59 p.m. on the 1st, it's late. Serve a notice of non-payment of rent right away. If the tenant says, I'll get it to you, that's fine. Once you serve the notice, the tenant has 14 days to void it. Okay. Then you file your application. Anytime up to the hearing, the tenant can pay off all the arrears that they owe. Even at the hearing, if you get an eviction order, when the order comes out, the tenant will have a further 11 days to pay everything they owe. So there's a lot of opportunity for tenants to pay off the debt without ever getting to a hearing or even after.
Okay.
So what happens is you come to me on the 2nd and say, my tenant didn't pay rent. We issue the N4 notice. Tenant gets it. They have, let's say we sent it by mail, so we add a couple days for service, and we give them a time that they have to pay it by. Tenant doesn't pay it. We file it. Once it's filed, it goes to the board system. After a few months, we'll get a hearing date. Hearing date's probably 60 days away, 90 days away. Then we go to the hearing. The Landlord and Tenant Board technically has 30 days to issue the order, or as a best practice, they'll issue the order within 30 days. But realistically, you're probably looking at 45 to 60 days for that order. Then the tenant has an opportunity to void it. Then after the voiding period, you go to the sheriff. Sheriff is usually 4 to 6 weeks. So from start to finish, you're probably looking at about 8 months, maybe even 9 months to get an eviction for non-payment of rent. Okay. Now, if you've just waited 3 months to start that process, you've added another year with no rent.
Right.
And that may not have been a problem when rent was $1,000 a month or $1,500 a month. Well, it was still a problem, but it may not have been debilitating financially when rent was low. But look, you go into Thornhill Woods, areas like that, rent's $5,000, $6,000, $7,000 a month for a full house. Yeah. So after 5 months at a $5,000 a month rent, you're at $25,000. Yeah. Another 2 months, you're at monetary jurisdiction of the Landlord and Tenant Board. That means that even if they owe you $70,000 when you get to hearing, the most you can collect is $35,000. Wow. Right? And to make it worse, most people who are charging $5,000 a month bought the house for $1.8, $1.9 million, not when it was $400,000 15 years ago, but they bought it for $1.9 million. Their mortgage is $5,000 a month.
They need
so
that
they need that money,
Exactly.
right?
Yeah.
Most small-time investors do not have
Yeah.
$70,000 in the bank in case their tenant stops paying rent.
Right.
So it can be debilitating.
So I mean, that's yeah, it's scary. At the same time, I think what I try to advise to my clients is, when you're investing into real estate, there's pros and cons, obviously, right?
Mm-hmm.
And you're not going to get successful without taking risks. So one of the risks is tenants not paying rent, but the qualification, or I guess the interviewing of the tenant process, who you should get, who you shouldn't get, that sometimes I feel can also get a little bit complicated because, for example, like, you want a specific type of tenant, but you can't discriminate, obviously, right? But how do you ask for, let's say, someone who's making sufficient income without, not discriminating somebody and saying, I'm not going to take you because you don't make enough money, right? How do you get away with that? How do you get around that?
So that's really a two-part question.
Okay.
So let me try and answer it as best I can. So we don't do tenant screening.
Right.
We advise people to work with, competent realtors.
Yeah.
That's important.
Yeah.
We advise people to work with tenant screening companies. So let's look at the screening process from that perspective for a moment. From that perspective, there's things that you can do to lessen your burden.
Yeah.
Ask a tenant for 12 months worth of bank statements.
Okay.
That shows rent leaving their account on the first
You're
of the
allowed
month.
to ask for those statements?
Absolutely,
Okay.
you can.
Okay. Yeah.
Right? You don't have to. I mean, the tenant can black out the fact that they spend $1,000 a month on liquor. You don't need to see that.
Okay.
All you need to see is
the
that
rent
on the
coming
first
out.
of the month.
Yeah.
Here's the rent, and it's gone out.
Yeah.
So beyond credit, beyond anything else,
Yeah.
because you know what? Up until very recently, rent didn't get reported on a tenant's credit bureau, so they could be running an 820 beacon score and not paying their rent. You would have no way of knowing about it. Also, prior to probably 2 years ago, landlord-tenant board decisions were anonymized. It didn't give the rental unit address, and it didn't give anything except for initials.
Okay.
So even if that tenant had been evicted 20 times prior for non-payment of rent, you as a realtor or as a tenant screening company would have no way of knowing that.
Yeah.
So be diligent. Don't just, and this is going to flow into the second part of it, don't just look at credit.
Okay.
Don't just look at income. I could lose my job tomorrow as soon as I'm in the unit. I could quit my job tomorrow as soon as I'm in the unit. And my credit may not be an accurate reflection of my payment history.
Right.
So ask for other information, right? Yeah. If I have a source of income sufficient to cover rent, a lot of mistakes. One thing which I'll get into in a minute is people applying income ratios. Well, I don't think that it's appropriate for a tenant to be in my house unless it's only 30% of their income.
Okay. Yeah.
That's discriminatory,
Yeah.
right? And I'll get into that.
Yeah.
But these are things that competent people will look for.
Right.
And it's far safer than saying, and I always say this too, it's far safer than saying to somebody, oh, well, your credit's bad, give me 6 months in advance.
Yeah.
Well, if they haven't been paying rent for a year and a half, they probably have 6 months worth of rent sitting in the bank.
True.
So that itself is not going to alleviate the fact that they're going to become non-paying tenants. They may move in, stop paying rent, and then once that 5 months of extra rent is burned up, never pay you a cent. And the problem is because you've collected that 6 months rent. This is something a lot of people don't know.
Yeah.
Let's say I have bad credit. And you say, Dan, I'm only going to let you move in if you prepay me a year's worth of rent, or prepay me 6 months worth of rent, and we'll apply the 5 months to the last 5 months of the tenancy. Okay? Yeah. Well, legally, you can't do that. Okay? It sounds nice. It looks nice. But legally, you can't do it.
Okay.
So I move in and I stop paying rent.
Right.
You file a notice for non-payment of rent and say, you owe me rent for this month.
Okay.
We get to the board 8 months later. That notice gets dismissed because you were holding 4 months of rent in hand. Yeah. So you had no right to serve me that notice to begin with. Yeah. And I, as the non-paying tenant, know that you have to start all over again. I'm still going to be there for another 8 months without paying a cent. Okay. So, I mean, we could probably do 3 podcasts on that. But
part 1, 2, 3.
Right, exactly. Yeah. So let's move over to the second part, which is the human rights component. So the thing is this: as a landlord, you have the right to determine who's going to live in your home.
Yeah.
What you do not have a right to do is discriminate
Okay.
in order to determine who lives in your home, whether that be race, sex, creed, sexual orientation, whatever it might be. I mean, if I pull up the Ontario Human Rights Code on my phone, which give me this indulgence for a moment.
Yeah.
So if I look at the Ontario Human Rights Code, and I look at the protected grounds for just housing, it's age, ancestry, color, race, citizenship, ethnic origin, place of origin, creed, disability, family status, marital status, gender identity, gender expression, receipt of public assistance, record of offenses, sex or sexual orientation. Now, record of offenses is just for employment only,
Okay.
so you can that's not something you have to worry about. And receipt of public assistance is housing only. So when you look at that laundry list of things, I mean, I can go on a Realtor right now, look up rentals, and I guarantee you the first ad
Yeah.
is contrary to something out of what I've just
Probably.
read. Right? So what we usually say to people is, look, do your due diligence.
Yeah.
First of all, the statute of limitations on a human rights complaint is a year from the date that it occurred.
Okay.
So keep your notes, keep your emails, keep everything that you can keep.
Yeah.
I had a situation which was just recently resolved where my client was a realtor. They got sued by a prospective tenant.
Yeah.
The prospective tenant alleged that they discriminated against them based on marital status and race.
Wow. Okay.
And in reality, what the real situation was that the landlord's realtor told them, look, there is my understanding that this woman's actually only going to be living in the house 3 days a week.
Right.
And the rest of the time she's going to be living off site where she works. My client said, well, if a pipe bursts on day one of that 4 days, I'm not going to know about it for 4 days. That has potential to cause a lot of damage. So I'm not going to rent to her. But in the tenant's mind, she was the perfect applicant.
Yeah.
And in her mind, all she could think of was, it must be because I'm a woman who's single with kids, and it must also be because I'm of this particular racialized group.
Right.
So that complaint, even though it was ultimately resolved, probably cost them $7,000 or $8,000 in legal fees.
Okay.
Right? As a realtor, you can also be held responsible.
Yeah.
Your brokerage can be held responsible. So what are some of the things that you don't put in a rental?
Yeah. Yeah.
When a realtor advertises and says you must have an 800 credit score to apply for this house, who are some of the people that could be excluded from that?
Right.
Looking at it just realistically, I'm not talking about ODSP. I'm not talking about social assistance. I'm talking single women who have been through a messy domestic situation,
exactly.
who are divorced with kids,
Yeah.
and when they separated from their spouse or got divorced from their spouse, their credit rating took a tank. So now, are you discriminating based on family status? Entirely possible. Because like I said to you before we started recording, in order for something to be deemed discriminatory, there doesn't need to be an email that says, we are refusing you based on the fact that you are a single mom with kids and are divorced. Right. They just need to be able to prove that they felt that as a result of the ad, they could not apply.
Yeah.
Right? So advertising a 3-bedroom apartment as not child friendly. In other words, don't come if you have kids.
Okay.
That is contrary to the code. Advertising, you must show me a pay stub, an employment letter. Now, this is probably the $5,000 house that we were talking about in Thornhill Woods.
Yeah.
This is probably not an issue. Most people applying for that house probably work and will be able to give you an employment letter and pay stubs.
Right.
But if you're advertising a place for $1,500 a month, that person may be an ODSP recipient. That person may be a welfare recipient. And you may not like the fact that they are a welfare or ODSP recipient, but they might be. And you advertising employment letter and pay stubs automatically excludes them.
Yeah.
Now you're looking at a human rights complaint.
Interesting. Okay.
And then when you and also what people don't realize, and I mean I could literally go on for hours, so I'll just make one more point and then we can move on. one of the other aspects of it as well, and I always use this example when I'm talking to realtors. So you have a client who has a basement apartment, it's $1,200 a month.
Yeah.
And you have two men, they're both early 20s. They both have a similar income. They both have a similar lifestyle. The only difference is that one is on ODSP and one is on working at Canadian Tire.
Mm.
And you choose to go with the guy at Canadian Tire only on the basis that he's working, that is discriminatory. Okay. Arguably, I'm not an adjudicator.
Yeah.
I can't tell you for sure, but arguably it's discriminatory because ultimately what ends up happening, and I get this all the time. Yeah, but the guy who's disabled might be home more. Maybe more wear and tear on my house. Right? Maybe my utilities will be higher. Well, that means that their disability that put them on ODSP is the reason you didn't make the decision to rent to them.
Yeah.
And the guy at Canadian Tire could get fired tomorrow and have no money and be in the exact same position. So what's going to cause you to, do they both require cosigners?
Yeah.
If they both require cosigners, that's not discriminatory.
Right.
So there's a lot of stuff.
Wow. Okay.
Right. We could literally do hours on discriminatory renting.
That's awesome. So I guess the next item I want to talk about was something that my clients go through a lot, again, is when they want to sell their property, right? So oftentimes what I come across is there's a tenant living in the property, the place is cluttered, obviously it's being lived in, and they want the tenant to move out because they want to stage it, they want to renovate it, they want to clean it so they can maximize their dollar. Now, there's two forms from which I understand, which even my clients are aware of, the N11, the N12, but I don't think we really know the actual details of it and how we can actually apply that. So if a client or a seller wants to sell their property and they want to evict their tenants on the grounds that, I want to renovate it so I can maximize my dollar, what's the best way to approach that? And can they do that? I mean, if tenant says, no, I'm going to live in here,
well, that's where an understanding of the law really comes into play. Okay. So the first thing that you as a landlord need to understand, especially, as a landlord in Ontario, maybe if you're a landlord somewhere else, not so much, but definitely a landlord in Ontario, your tenants have security of tenure. Okay. Meaning that once they're in the property, there's only 3 ways for that tenancy to terminate. Okay. The tenant leaves.
On their own.
On their own. The tenant is evicted by conduct, not paying rent, damage to property, something of that nature.
Okay.
Or the third is by agreement.
Okay.
Which would be an N11 or an N9.
Both tenant and landlord are agreeing that.
Right.
The lease will end. Okay. Yeah.
So landlord wants to sell their property, tenants in there. Guess what? Tenants got to stay there. Because with security of tenure, if the person buying the property is also an investor and doesn't intend to live in the unit, then that tenant has the right to stay.
Okay.
Now, you can disagree with that statement. You can say it's not fair. It doesn't matter that it's not fair. That's the law. Okay? So this is what I tell people. It's a business case. Everything is always a business case. There's this thing that became very popular during the pandemic, and you're not going to like me for saying this. A lot of the reason was realtors who didn't know any better. Okay? Doing cash for keys. Okay. Now, why is that important? I'm going to tell you. Even prior to the pandemic, probably for as long as tenancy legislation has existed in this province, definitely since 2006, a tenant has the right to a hearing under all circumstances, except for an N11. Okay? So you serve that 60-day notice. That doesn't mean the tenant leaves. You have to file it with the board, and you have to go to a board for a hearing. Prior to the pandemic, when you could get to the hearing in 60 days, you could probably get vacant possession in 90 or 120 days. Not much of a problem. But the pandemic didn't change that. So now you have people granting vacant possession clauses, seller agent or buyer agents doing vacant possession clauses 30, 60, 90 days on a tenanted property. And it's just not going to happen. So how do you avoid it? Here's what I tell people. Let's go back to Thornhill Woods because it's an area I'm familiar with. A house in Thornhill Woods, when it was first built, might have sold for $468,000. If you were the original owner, you bought it for $468,000 or less. I know because I looked. It's now worth 1.8, 1.9 million, and you've been renting it the whole time. So you obviously, understandably, want to cash out and get that investment. Maybe you want to buy 2 or 3 rental properties with that money and, really expand. Yeah. But your tenant who's been living there for 10 years, who pays $2,500 a month rent, the next place they go to is going to be $5,000 a month.
Right.
You already know this in advance. Yeah. Call the tenant. Say, look, I want to sell, and I want to sell vacant. Not lying to you. I'm not saying I'm moving in. I don't know what the purchaser is going to do. So let's come to an agreement.
Yeah.
Maybe that's a year's worth of rent differential. You're paying $2,500 now. A new place is $5,000. Maybe, I'll pay you 12 months of rent differential. Yeah. Maybe I'll throw an extra couple $1,000s in there for moving. It's a lot of money. Yeah. Don't get me wrong. It's a lot of money. But if you're making $1.2 million on a house, maybe it's not so much business. Money, right? Yeah. And what does that do? It allows you to renovate the now 20-year-old kitchen and bathroom and make it more modern. So the person looking at it has more of an incentive to buy. Maybe that gives you an extra $100,000 on your house, right? So maybe it means replacing the old builder laminates with better hardwood. Yeah. That increases the value in your sale price. Take that step. Yeah. If you can get vacant possession by means of an N11, do it.
Right.
If you can't and they're stuck, then make sure the person who's selling your house, and this is why it's so important to have a guy like you, Asin, because you know how to sell houses, right? And with respect, very similar to our profession, you get new people who don't necessarily know how to sell houses. So you get a situation where the realtor sells the house, they're counting their commission before the place closes, but they allowed you to close with a vacant possession clause for 60 days after the deal is done. Yeah. You're never going to get vacant possession in 60 days.
Right.
So guess what? Now you have 3 choices. You can either talk to the purchaser about extending their close, which works if they rent or haven't sold their property yet. Right. You could pay a penalty. Sometimes I've heard pretty significant penalties, $50,000, $100,000 to late close. Wow. Or get them to assume the tenant until you can get an eviction. Yeah. But if they're like most of us, they're not bridging those 2 houses. They've already sold the other property and they need to move. And the third is, remember that $40,000 we were saying is really, really expensive? Yeah. Now you're paying $80,000 because it's still cheaper than getting sued.
Wow.
Right? Crazy, yeah. It's still cheaper than getting sued for failing to close on a property. Right? So that's important. As a purchaser's agent, that question has to be asked as well. Like, you have tenants in there. Like, have they agreed to leave? Have they signed documentation that they're leaving? Because if they haven't signed documentation that they're leaving, let's move over and look at another house. No matter how in love you are with this one, it's going to be a year before you live there.
Yeah. But the N12 form, when you sell the property, right, and you serve the N12, at that point, if the purchaser is moving in, that's a reasonable cause for the tenant to leave, no, or not?
It's a reasonable cause, but the issue is not the cause. Okay. The issue is, especially in a backlogged system that we're in right now, that the tenant has the right to a hearing.
Right.
Now, so the notice says, and the notice says, if you disagree with this notice, you don't have to leave.
Yeah.
Now,
that's a risk.
Is the notice worded properly?
Yeah.
That's a debate for another time. Is the act set up properly? That's a debate for another time. Because again, we're working within the legislation that we have.
Right.
So, you may genuinely intend to live there, and you will probably be successful in getting the eviction.
Yeah.
But how long are you willing to wait?
Yeah. That's the question. Yeah.
Right? And you just have to understand, right? The notice is nothing. The notice is the intention to move in. Then you file it. Then you go to a hearing. Hopefully, in a year from now, we'll be back to 45-day hearings, and this will just be a bad memory that no one has to think about.
So the tenant has a right to a hearing, even if the property is sold. In the case that, let's say, the tenant decides to stay, but is signed an N11 form, they still have a right to a hearing? Is that...
So if the tenant has signed an N11,
Yeah.
hopefully somebody like me has been consulted,
Okay.
and that N11 has been filed with the board,
Yeah.
and what's called an ex parte eviction order has been granted,
Yeah.
which says if the tenant fails to vacate on the agreed upon date,
Right.
the landlord can walk the order to the sheriff, and the sheriff will give vacant possession of the property. The earlier you do it, the better. There's no point in, it's because especially because you have to wait for an order, which could take 6 to 8 weeks on its own.
Yeah.
If you're signing a vacant possession that's 15 days away,
Yeah.
you're never going to have that order back in time.
Okay.
So what you want to try and do is think 90 days in advance or 60 days in advance, so you have time to file it, get the order back.
Yeah.
The period of time that the tenant has the ability to file a stay and say, I now disagree with this order, has elapsed,
Right.
and you can now move forward.
Okay. And for the N12, I know, so one reason to serve the N12 is if you sold a property to a purchaser who's going to move in.
Right.
I've heard, I don't know if it's true, but I've heard that the tenant has a right to ask the new buyer to bring an affidavit that they're moving. Is that true, or does that not? It's not required.
It's part of the application process.
Okay.
So whether you are an owner or a purchaser,
Yeah.
you have to have a declaration or an affidavit that states that you intend to move into the property.
Okay.
Now, what that affidavit says is different based on whether you are an owner or a purchaser.
Yeah.
So an owner has to swear that they intend to move into the property, they intend to live there for at least 12 months, and that they
Right.
won't sell or re-rent for at least 12 months.
Okay.
A purchaser is required to declare or swear that they intend to take occupancy of the unit. The 1 year doesn't exist.
Okay.
But let's be honest, the legislation is constantly changing, and if too many landlords abuse that,
Yeah.
or if too many purchasers abuse that and just move people out and start moving people in,
Yeah.
you'll have the 12 months
Right.
there as well. And let me just say, one thing for sure, a bad faith application is money in the bank
Yeah.
for the person who brings it.
Okay.
Okay. The tenant gets the difference in rent for a period of 12 months. So let's just say for easy numbers, they were paying 1,000, now they're paying 2, so they're going to get 12 grand.
Yeah.
Then the legislation says the landlord could be ordered to pay up to a year's worth of rent in general damages.
Yeah.
That's another 12 grand. Then the tenant's entitled to reasonable moving expenses. So
Yeah.
if they can prove they spent $1,500 and that was reasonable, the tenant's entitled to that too.
Yeah.
And then if let's say 1,000 was all inclusive, 2,000 is plus, that's all going to be awarded against the landlord as damages. And the landlord will say, fine, I'll never pay it. But guess what? You have a property,
Yeah.
and that tenant's going to register a lien on your house.
Yeah.
And the moment you sell it or refinance it, you're paying
You're
that
gonna end
money,
up
whether
paying
you
it.
like it or not.
Yeah. Yeah. And in the event, let's say a client or a seller has a relative who wants to move into the property, right? A mother, or father, or brother, or sister, and they don't actually move in, but the tenants have moved out based on that reason, and they find out the next day the property's up for rent for like $2,000 more.
Bad
I'm
faith
sure they have
application.
recourse for that, 100%.
Yeah, bad faith application.
Yeah.
In fact, the Act has a provision built in. I don't know off the top of my head.
Yeah.
My mind is telling me it's 88, but it probably isn't.
Yeah.
That says that if you do want to advertise the property for rent within that 12-month period,
Yeah.
because there was a material change in circumstance, you actually have to offer the unit back to your original tenant
Okay.
at the same rent.
So you got to call them and say, do you want to move back in?
That's right.
And that should be documented too, right?
Oh,
Because
absolutely. it should be.
if they ask you,
Yeah.
okay, I sent them an email or a text.
Well, look,
saying
if they
that.
bring a bad faith application against you and you have an email that says, hey, tenant, my son who was going to be going to University of Toronto
Right.
is now going to University in Ottawa, so I no longer need the house for my son.
Yeah.
Would you like to move
wanna move
in
back
at
in.
the exact same rent that you were paying before, which is $1,000 cheaper than what you're paying now?
Yeah.
If the tenant says no and brings a bad faith application, the adjudicator is going to say, well,
Oh, yeah.
you were offered the unit back at the same rent you were paying
Yeah,
before.
you didn't take it.
What's
Yeah.
the issue?
Yeah. Makes sense. Okay. Well, that's awesome. I think that is one topic that I always get with my clients. And the second subject that we always come across is rent increases. So I know we have a law for a cap when it comes to certain properties. Now with today's environment, like I had a client call me the other day saying that my mortgage has gone up by $600 and I can't afford to keep the house unless I increase the rent. If he goes to his tenant and they mutually agree that, yes, we'll pay the extra money, but legally it's not allowed, can that tenant still have recourse later on, even though they agreed to the illegal rent increase based on the situation?
So this is where relationship is key. Okay. So there used to be a case called Price versus Turnbull Grove that said that if an illegal rent increase is made, it will forever be illegal.
Okay.
Right? So under the Real Property Limitations Act and the Residential Tenancies Act, if you increase the rent illegally 10 years ago, presumably every increase since has been illegal.
Yeah.
So the rent is now what it was before, and you now owe all this money back.
Right.
When Bill 184 came out, was brought into power, Bill 184 said that a rent paid for 12 months is now the legal rent.
Okay.
You can't undo it. Doesn't matter if it was done properly or not. After 12 months, this is the rent.
Okay.
Now, this is where relationship comes into play. You can only legally increase the rent above the based on the Ontario guideline.
Yeah.
So let's say anything before November 2018.
Right.
This year it's 2.5%, and you can only raise it once every 12 months. If your house was built after November 2018, and when I say built, I mean occupied for the first time after November 2018.
Yeah.
I can't remember the date. I think it was November 17th or something like that. It is not covered under rent control, and you can raise the rent as much as you want.
Yeah.
Once every 12 months.
Right.
On the appropriate form. Now, if you say to a tenant, look, you're paying $1,000 a month. It's $2,500 below market value. My mortgage went up $600 a month. You don't have to pay the increase. I agree. You don't have to pay it.
Yeah.
Okay. But if you don't pay it, I'm going to have no choice but to sell.
Yeah.
So are you willing, not to market rent, I'm not being greedy, are you just willing to pay me the extra $600 a month my mortgage went up? If the tenant agrees and they don't dispute it for 12 months, then that's the rent.
Okay.
If they dispute it at any time during the 12 months, then you're done. It'll get undone.
Yeah.
It's also important to note that you do not want to enter into a new lease agreement.
Right.
Because what ends up happening is, so I'm a tenant, you've illegally increased my rent, let's say $700 a month. I say, well, I'll do it, but only to give me a new lease.
Yeah.
And I want a 2-year lease this time to make sure you can't evict me for 2 years. And then the tenant takes it to the board and fights the eviction. The rent increase will get unspun, but you'll still be in a 2-year lease that prevents you from evicting them for 2 years.
Oh, wow. Okay.
So this is why legal advice is so important.
Yeah. So that relationship is really key, I think,
right?
Landlord and tenant, right? Yeah. At the same time, it's like I think I've heard you say on another podcast is that this is your business as a landlord. This is your business. Your tenant is your customer, and you've got to treat it that way where you got to keep your customers happy. But if something goes off, you have to make sure that's not personal, like you said about non-payment of rent, where you're going to go and issue the notice. But at the end of the day, it is a business, and that's how you got to look at it. I think most people, unfortunately, don't look at it that way. And whether they have 1 property or 5 properties, unfortunately, they think they can do whatever they want. And I have to educate my clients sometimes and tell them, you can't do this to your tenant, because if you were in their shoes, how would you feel?
Right.
And then they go back into perspective and say, okay, you know what? I wouldn't want to be evicted illegally. How would I feel about it? So definitely there's that back and forth. I want to ask some rapid fire questions now, because there's a lot of myths that landlords feel that they have rights over.
I'll try and answer them. I'll try and answer them in a rapid fire way.
This will be fun. Lawn care and snow removal. Who's responsible for that?
Okay. Montgomery and Van is the case. If it is more than 1 unit, the landlord is always responsible. Okay. What a lot of landlords will do is they will do a separate maintenance and lawn care contract with the tenant that says, you're paying me $3,000 a month rent. I will
Yeah.
pay you $100 a month,
Okay.
not discount. I will pay you $100 a month to mow the lawn and shovel the snow in the winter. And that's acceptable. That's
Okay.
fine. Because then if they breach that contract, it's not governed by the act.
Right.
But they are ultimately responsible.
Okay.
If it is a single unit home, some people will argue the landlord is still responsible.
Right.
My personal opinion on that is that they would not be.
Okay. Interesting. Okay. Inspection. Can a landlord inspect the property whenever they want?
They have to give 24 hours notice,
Yeah.
and it has to be for a legitimate reason.
Okay.
So when you get these landlords who are like, I'm going to inspect the property once a month,
Yeah.
that's not a legitimate reason.
Okay.
Twice a year, sure,
Yeah.
no problem.
Okay.
If there's a legitimate other reason to be there, sure, no
Right.
problem.
Gotcha.
But you have to have a legitimate reason.
Okay. Can a tenant break a lease in the middle of the lease agreement? Let's say they've signed a 1-year lease, but they've bought a house and they want to leave in 6 months. Can they do that without any recourse, I guess, on their end?
So let me put it to you this way. There are about 8 provisions, no, not 8, 5 provisions within the Residential Tenancies Act that would allow that tenant to break that lease within 30 days.
Okay.
Okay. Requesting a sublet. If you deny the sublet, tenant can break the lease.
Okay.
Request an assignment. If you deny the assignment, tenant can break the lease.
Okay.
The number of ways. Here's the one that most people go with. I, as a tenant, don't want to pay my rent this month. So it's May, and I haven't paid for May.
Okay.
You serve me an N4.
Yeah.
The N4 says you must vacate by May 19th. Tenant says, no problem.
So they bought themselves time.
Right?
Yeah.
They vacate.
Yeah.
You have last month's rent. They don't owe you anything.
Right.
There's nothing you can go to the board. Their lease is broken. Sayonara.
Yeah. Okay. Perfect. Next question was subletting, actually. Can a landlord turn down a potential sublet if they don't like the tenant that comes in from the current tenant?
So a sublet is different than an assignment.
Okay.
In a sublet, the original tenant is ultimately responsible for
Right.
rent and damage. So, I mean, theoretically, you could turn one down,
Yeah.
but a lot of your danger is gone because
Okay.
your tenant is ultimately still responsible.
Right.
Where people don't realize is this: a sublet can only be for the length of a term of a tenancy.
Okay.
So if you have a 1-year tenancy
Yeah.
agreement, you could sublet theoretically up to the end of that year, at
Right.
which case you would terminate your tenancy. But conversely, leases in Ontario go month to month after the first year unless
Yeah.
you renew,
Yeah.
which I don't advise, but I'll
Okay.
get into that in a minute. Which means that you are technically only able to sublet your unit for
Yeah.
a month less a day,
Okay.
because you have to, anything longer than that exceeds your term of your tenancy.
Right.
So, if a tenant comes to you and says, I want to sublet my 3-month property for 3 months, and they're on a month-to-month lease, you don't have to consent to that. It's not
Okay.
unreasonable withhold consent, and their recourse is to terminate their tenancy after 30 days.
Gotcha. Okay. This one is a bit broad question, but repairs and maintenance. What would the landlord typically be responsible for? And the minor items, for example, changing a light bulb, maybe unclogging a clogged toilet, would the tenant be responsible for that, or is that landlord's responsibility?
Sorry. So let me explain to you this way.
Yeah.
If it is a single dwelling unit, like
Yeah.
a house, a well-constructed lease agreement will say that a tenant is responsible for anything that is not a special order consumable. Furnace filter, light bulbs,
Okay.
things like that.
Yeah.
If it is in the lease and it's not a special order, because look, they have these bathroom chandeliers where the bulb's like $600,
Okay.
that would be a special order.
For sure. Yeah.
Right? But if it's just a non-special order consumable, it's probably in the lease. If it's not in the lease, fine, whatever.
Yeah.
Most people don't raise a stink about it.
Yeah.
Ultimately, the landlord is responsible under Section 20 to maintain the residential unit in a way that's fit for habitation.
Okay.
So if the tenant breaks the stove, yes, the landlord is responsible for replacing the stove.
Okay.
If the tenant clogs the toilet because they're flushing unmentionables down the toilet,
Yeah.
yes, the landlord is responsible to fix those
Okay.
things. But once they've fixed it, they can now take the tenant to the landlord and tenant board and do one of two things. They can either seek their eviction for the damage
Okay.
or seek payment for the damage.
Right.
Right? Now, as we like to like, if you have a $300 electric stove in the
Yeah.
kitchen and they break it, you can't replace it with a $2,000
Yeah.
glass top
No.
or gas stove and then say, pay me the $2,000. You
Right.
can't do that. But yeah, absolutely. They would fix it and then they would say
Okay.
to the tenant, this is yours. And it also can't be wear and tear.
Yeah.
Right. And I use this as an example all the time. When I got divorced, I moved into a really old home. I don't think the hardwood floors have been redone in about 20 years. There was no clear coat left on them at all.
Okay.
I could literally scratch them walking in my bare feet.
Yeah.
Okay. That would not be damage.
Okay.
That would be wear and tear
Right.
because it's not maintained.
Yeah.
So what I always tell clients is before somebody takes occupancy, take a lot of pictures.
Take photos. Yeah.
A lot
Yeah.
of photos. And I'm not saying,
Yeah.
oh, I have the realtor listing.
Yeah,
So
yeah.
that's no. Take photos of the kitchen. Open every drawer. Open every cupboard.
Okay.
Take photos
Wow,
of it.
that's
Take
tedious.
photos inside.
Yeah.
Right? Close the doors. Take photos of the stovetop.
Right.
Take photos of the fan. Take photos of the fridge. Take photos in the bathroom. Take photos of the vanity. Open the vanity. Take photos underneath the vanity. Because ultimately what's going to happen is if that tenant damages the property, their first defense is going to be, well, it was like that when I moved in.
Yeah.
And if the landlord doesn't have detailed pictures,
Yeah.
the adjudicator is going to say, they may have damaged it, but you have no proof that they
Yeah.
damaged it.
Yeah.
Whereas now if you have all these photos and all these images and everything
have
else,
proof.
you
You
have
have proof.
actual proof.
Yeah.
Look, here is the kitchen underneath the sink
Yeah.
that shows no mold and everything in good working order.
Yeah.
And here's 9 months later where the tenant has cracked the pipe and there's now mold and all these other things in the unit.
Yeah, I think just taking the extra half an hour or an hour to take those photos will save you a lot of money at the end of the day. So it's worth
We're
it.
not in the 1990s
Yeah.
where you have to run to Walmart to
Exactly.
get things done.
You've got
You
your
can
phone.
do it on your phone. This is a better
Yeah.
camera than you could have bought 20
Exactly.
years ago.
Exactly. I just got a couple of more. Can a landlord ask for advance payment of rent? And if he does, I'm sorry, if the tenant voluntarily agrees to it, is that still okay, or can the tenant ask for it back later on?
So here's the caveat. Okay. Yes, a tenant can voluntarily offer to pay more than first and last month's
Yeah.
rent. Here's how that works. You as a realtor have a client. You say to the client, look, you're not the strongest rental candidate. You may want to consider offering some money up front.
Yeah.
Okay? You go, and when you place your offer, it's on the offer. Here's everything, but we understand my client's not the strongest applicant, so we're willing to pay 6 months.
Okay.
Okay? They accept. You're off to the races. It was a voluntary payment. As long as those extra 5 months are applied to the first 5 months and not the last
Got
5
it.
months, it's
Okay.
not an illegal deposit.
Okay.
Okay? That's important.
Yeah.
It's only an illegal deposit if you apply it later.
To the back
To
end
the
of the
last
lease.
time. The only thing
Okay.
you can keep is your last month's rent.
Yeah.
Everything else, apply it to the front.
Okay.
If you have a client that is a weaker client, and they say, we'll only rent to you if you give us 6 months more,
Yeah.
and you voluntarily give the 6 months, that is an illegal deposit because the tenancy was determined based on that
Okay. On that.
demand.
Okay.
And then, especially if you now say, we'll
Yeah.
apply it to the last 5 months,
Right.
you've really cooked your goose.
Okay.
Right?
So I can't ask for it. If they come and tell me that here's
They
6
offer
months, then I can take it.
Right.
Basically.
And I mean,
Okay.
first offer, you didn't know it was coming,
Yeah.
entirely voluntary. That's fine.
That's fine. Okay.
Right. But if you are the landlord and you say, look, credit rating 590, not really good, that's another discriminatory thing we'll talk
Right.
about really quick.
Yeah.
Right. Pay me these 8 months
Yeah.
and we'll consider it. That's now an illegal demand for rent, even if it's provided
Yeah.
willingly. because it was contingent. The tenancy was contingent upon the deposit.
Got it.
Now, when you're evaluating credit score, this again falls under the Ontario Human Rights Code. Ultimately, a single mom with 3 kids who's just been through a messy domestic situation, maybe
She's
didn't
gonna have
work
a
the
low
whole
score.
time,
Yeah.
she's going to have a low score.
Yeah.
You have an obligation as a landlord to fully investigate why that score is low.
Right.
Okay? Even to the point of saying, well, look, you have defaulted on these 6 credit cards. That's why your score is low. And she says, yeah, I didn't have a choice. The credit cards were in my name, but my husband was paying them.
Yeah.
And when I left, I wasn't able to pay, so I'm doing things to fix it. You have an obligation to explore that person as a possible tenant. Do you have a cosigner available? Do you have money in the bank? Is there some way to secure this tenancy for you?
Right.
Having said that, if it's just my name's Dan and I'm a 47-year-old and my beacon score is 400, and the reason my beacon score is 400 is because I've had 3 cars repossessed and I've got all these things on my thing, you're not obligated to accept me just based on that.
Right.
Right? I mean, you do have to evaluate it, though.
Okay.
So one of the reasons most people offer more than they have to
Yeah.
is because there's a negative.
Right.
So you, as the representing the purchaser, should explore that.
Okay.
A number of reasons why you should explore it is so that you have the evidence to show the other realtor who will ultimately question you. And they, as a realtor, have an obligation to explore it so that when they present it to their client, they're presenting it in a non-discriminatory way.
Gotcha. Okay. Last one I have here is about post-dated checks. So if you're old school, can you demand post-dated checks, or is it the tenant's choice to provide that for payment?
You cannot demand post-dated checks, again, if the tenancy is contingent upon post-dated checks.
Right.
We live in 2023.
Yeah.
There's e-transfers. Okay. Unless the rent is like $5,000 a month and you have a $3,000 e-transfer limit,
Right.
because you have no obligation to accept $3,000 on the first and $2,000 on the second.
Yeah.
Your right is to receive your full rent on the first.
Okay.
And you can have the right to say to them, listen, my right is to receive $5,000 on the first. I don't want to do 2 payments.
Yeah.
Right? Like, what happens on January 1st when the
Yeah.
banks are closed? Do you send me $3,000 on the second and then $2,000 on the third? Like,
Yeah.
I don't want to deal with this. So I don't care how you get the money to me, but it has to be on the first of the month.
Right.
Post-dated checks are probably easier.
Yeah.
Right? If they say, fine, here's post-dated checks, that's fine.
Okay.
But you can't say, I will only rent to you if you provide me post-dated checks.
Gotcha. Okay. That's great knowledge right there. So we'll leave the real estate and the legal stuff aside for now. I'm going to ask some personal fun questions.
Sure.
That I like to ask my guests. The first question I have is, where's your favorite place to travel that you haven't been to before?
That I haven't been
You
to.
haven't been to before, yeah.
Ooh. Hawaii.
Hawaii? Okay. I've never been there either. That's on my bucket list too.
Like one of my favorite shows was Hawaii Five-0.
Okay.
And you just kind of look at it and you go, oh my God, it's freaking beautiful there.
Yeah.
So I've always wanted to go to Hawaii or Australia.
Nice.
Right. Except in Australia, they have spiders that kill you. So that might be the determining factor.
I had no idea. Next question is, what's your favorite movie or TV show? You're a movie guy, I think.
Yeah, I'm also a huge nerd, though. So I think like any of this, I think some of the Star Wars or Star Trek movies would be up there as far as like favorite movies.
All right.
Favorite TV shows, again, like, Star Wars, Star Trek. Like, I'm a huge nerd.
Are you a Star Wars nerd?
I'm a huge nerd.
I'm a huge nerd too, by the way.
Yeah.
I know everything about it, so
Definitely.
we can chat offline.
Yeah.
Last question is, what's the best piece of advice that has been given to you that you still resonate till today?
I don't know if I can say it on here. The best piece of advice I probably received was a mentor just said, look, some people are just assholes. You're not going to be able to change it.
Yeah.
You're not going to be able to fix it. You're not going to be able to behave your way out of it.
Yeah.
They're just assholes.
Yeah.
Don't try.
Right.
So I do that. And the second piece of advice I actually received and then found in a book later called The 7 Habits of Highly Effective People, which, if you haven't read it, is a great book. And it says you can never talk your way out of a situation that you behaved yourself into.
Nice. Yeah.
So I go by those things quite often.
Awesome. That's a great way to wrap it up. I think just to sum it up from my perspective is that I know in the headlines we see a lot of news about landlords, not getting paid their rent for a year or so. But honestly and truly, I think that is the minority. I think the majority of cases that I come across is that landlords and tenants have a good relationship, right? There's that one off, two off. Now there's probably more, but those get thrown out in the headlines a lot. But if you are an investor, I think like Dan said, you got to watch this video, watch the other stuff, and understand that there are ways to go about things. You have to understand the law. You have to be knowledgeable. So reach out to Dan if you have any questions, and use their services, because they are going to help guide you in the right direction. Don't wait 3, 4, 5 months for arrears and then reach out. Reach out right away to know the right facts. But there's resources out there for you guys, so use that to the best of your ability. But thanks so much. I really appreciate you coming on.
Hey, you're welcome. And if anybody ever does want to reach out, just go to sfg.legal.
Got it.
And reach out to us through our site and one of our litigation.
Perfect. And we're going to have his site in the content below as well. So reach out to him. Thanks so much, guys. Have a wonderful day. Thank you.